Welcome to the Big Law Business Report, where big law meets big business. Joining me in the studio today are two preeminent intellectual property attorneys, Daryll Motly and Phill Hampton. Gentlemen, thank you for joining me on the show today.
Thank you for having us.
So besides being intellectual property attorneys, both you guys have engineering backgrounds. Daryll, if you can, touch a little bit on your engineering background. How's that helping you with the practice of law and how you help your clients?
Sure, Brian. Thanks for being here.
Of course.
My engineering background deals with mechanical, electrical type of technology as well, and I can interface what I do with looking at the clients and how they may want to do innovation and protect them intellectual property and patents on the patent side as well.
Gotcha.
So interview them and figure out what's the best way to protect what they have.
So when you talk about mechanical and electrical, be a little bit more specific about it. Are you working with technology companies that maybe manufacture cell phones or laptops or wearables or all of the above, or neither A, B, or C?
Absolutely, all the above. Wearables, from footwear to wearables on the wrists, to cell phones, to laptop computers, to neuro stents in the brain.
Wow.
To all kinds of different medical devices as well.
Gotcha. And Phill, how does your engineering background help you in your practice of law and working with your clients?
Well, I mostly do patent infringement litigation.
So let's talk. So what's patent infringement litigation? For those of us who may be in the audience or sitting very close to you that isn't Daryll Motly, for those of us who may not know what that is, what's that, Phill?
It's when Daryll writes a great patent for his client, and then his client realizes that a competitor is infringing upon his patent rights.
Okay.
Then, I will file suit against the infringer, and there'll be a big patent infringement suit. But I also, I'm a little bit older than Daryll.
Oh, you're a little bit older than all of us, right?
So when I started, I also did a lot of trademark work.
Right.
So right now, I still do a fair amount of trademark litigation, and I also do a lot of expert witnessing in trademark cases.
Got you. So in this expert witness work that you do on behalf, I guess, of clients or various other companies or whatever, what primarily are you sharing with them? What are you doing? Again, we touched on the whole engineering background. How does that come into play when you're acting as an expert witness? Or does it not come into play at all?
It doesn't come into play on the trademark side because, again, trademarks, unlike patents, you don't need a technical specialty to practice trademark law. What I do basically when I'm an expert witness in a trademark case, I try to educate the ultimate trier of fact, be it the judge or the jury, as to what the procedures of the U.S. Patent and Trademark Office are, or on some of the more difficult areas of the law, try to educate them as to how they should look at a problem from my client's perspective, of course.
Right. Well, I would sincerely hope so. So, Daryll, if you can, share a couple of instances where you've worked with some of your clients who've had some intellectual property challenges. And obviously, don't need to mention names, but kind of walk me through a procedure, or kind of walk me through a process where you've had something along those lines.
Sure. Some clients get letters sent from other patent attorneys that they say that
They come from Phill?
they could come from Phill.
Possibly.
So I'll get that letter and I'll evaluate the situation. And sometimes clients we may advise clients to maybe do a design around or the slightly design change to be clear that there's no issues at all. And one of my clients, we did a design around. They sold more material, got a new patent, and did very well, with no litigation involved. So they're very happy.
Got you. So did they go from? I mean, do you remember the dollar amount they went from, or was it just more market share, or
more market share? They were happy. I mean, the average patent litigation is about $2 million or so, and
right.
Low at risk, and it could be more. Phill could say, but so this is a small case, $2 million, right? So,
right, exactly.
So they were happy to save a lot of those funds. So.
Right. So basically, if I can understand what you're saying correctly, Daryll, so you sort of took like a holistic and comprehensive look at this and said, okay, here's what could happen. or here's a way to kind of work around
Right.
it. So I think sometimes, a lot of business people are find a little consternation with their attorneys because they feel they're just running the meter up on them, that sort of thing. And
I've heard that before from
yeah,
business
that's right.
people.
Yeah, I mean, you might have to Google it or something like that. So, but it sounds like to me the approach that you took with this particular client was you were taking much more of a holistic approach. Say, look, in a comprehensive approach, here's a workaround, here's a way that we can do this where it may not cost as much money, or even if it did cost a certain amount, it was more of an investment because in the long term, in the long run, it allowed their company to remain to be viable. They weren't infringing on anyone's patent, and they can continue to do business.
And they got more patents from new technology by more innovation.
Right. So Phill, share a couple of, I know you probably have a few more stories than Daryll. So just share a couple of instances where you've worked with some of your clients.
Well, at first, I want to dovetail on what Daryll says.
Sure.
I mean, folks should never be afraid to litigate, but you should never want to litigate first off. Because generally speaking, if you're paying your lawyers $2-3 million on a patent infringement case, that's $2 or $3 million that you, the businessman, will not have.
Well, that's true.
So, but there are times when you have to go ahead and sue, and sometimes you have to be very creative. The one thing I like about intellectual property litigation is most of the time the judges and the juries aren't quite familiar with it.
Sure.
So therefore, a creative lawyer can actually sometimes you get a better result than you should have. Like, just last year I was in a trade secret case where the only really realizable damages were only about $100,000, and we got a $10 million jury verdict.
Wow.
That's
So-
pretty good.
That's a good day.
So we were very creative in how we put that.
It would appear
together.
that way from all indications.
And I think that's the one thing that intellectual property attorneys, a big advantage that we have is that a lot of time the judges and the juries don't quite understand. My background's chemical,
Sure.
and in a chemical litigation, you have a jury of maybe 8 people, 5 of whom failed high school chemistry, and they're the ones who are deciding whether or not a patent's infringed. So therefore, you as the lawyer have to be very convincing that your story is the correct story, and you have to be very careful in picking your technical experts that they come across believable. The
Right.
big thing is they have to be
Yeah,
believable.
sure.
Absolutely, absolutely. Well, gentlemen, I tell you, this is a great conversation, and I'm definitely going to need to invite you back to continue this conversation on in the very near future. Phill, Daryll, thank you so much for joining me on the show today.
Thank you, Brian.
Thank you, Brian.
All right, we'll be right back.